talk about the components of the attorney-client relationship. It's an actual case. It's 3 pages. It's being due in 2 weeks. It's not to unnerve you or anything. You get full credit. It's worth 25 points, but put in the effort. Plan accordingly so you can get it in on time. Unanticipated things happen, of course, but make sure you look at the deadline. And I think the problem will be self-explanatory. Sort of is, if you approach it correctly, I would just review my notes. No additional research is necessary. Review your notes, look at the rules and the comments, look at our textbook, and then sit down and write it. It'll deal with all the components of the attorney-client relationship that we talked about. At least they'll be evident to you in the context of the problem. This is one reason I'm doing this is just to show you the dirty underbelly of law practice. This is an attorney who actually did this only a couple years ago. It's bad. So it's just to show you that these things happen, and that's why we got this class, and that's why you're studying it through. Apart from it being a required course in MPRE exams, these rules are going to stay with you throughout your career. So it's important that you know what they say and how they work. So we're back to conflicts, and we have been dealing with Rule 1.7, and we defined 2 things of concurrent conflicts. Directly adverse means you're going against the client's interest. Doesn't matter if it's unrelated. We know that from comment 6 to Rule 1.7. And so this notion of undivided loyalty is very real to us. You don't want to betray the client by going against the client's interest. So we get directly adverse, or if the concurrent conflict, if the conflict is not directly adverse, it could be materially limited. And that's a different type of conflict. That means because of something outside of the attorney-client relationship, you cannot do fully what you would normally do for your current client. So there might be some previous representation, there might be another current client, there might be some obligation outside of the attorney-client relationship that impacts what you are able to do. And the sure sign of that is you can't even consider all the options that are available to you to advance your client's interest. So we said those are the 2 type of current conflicts, directly adverse or materially limited, but even if you do have those limitations in terms of a conflict, you may be able to deal with that conflict by getting informed consent. So notwithstanding the existence of a concurrent conflict of interest that is either directly adverse or materially limited, a lawyer may represent a client if. So all you're saying here is, although there is a conflict of interest, representation may proceed if these 4 things under 1.7b are satisfied. Directly adverse. So even though you have a concurrent conflict, you go down and ask the next question, can this conflict be resolved through informed consent? But you need all 3 of those things. Although there is a conflict, representation may continue if, 1, I'll just put competent and diligent. So you as an attorney reasonably believe that you can provide competent and diligent representation, notice this, to each affected client. So that's telling you need to have this conversation about pros and cons with your client. But you need all 3 of these things and informed consent. So even though there is a concurrent conflict, a lawyer may represent if reasonably believes that that lawyer can provide competent and diligent representation to each affected client, not prohibited by law, not the same action or transaction. This means you cannot be on both sides of the V. And informed consent from each client. So that's a little bit more than yes, this is what I'm going to do, this is what could happen. You have to have that discussion. And each affected client gives informed consent in writing. So that's pretty much what we did yesterday Tuesday, in terms of looking at conflicts. And then we took that proposition and then ran it through these hypotheticals. We did the injured passengers, and in that scenario, we wanted to illustrate 2 clients unified in the commonality of interest, but with different needs. And when we first started out, those needs are fine. We want to save money, we want this attorneys to represent them, and we want to move forward, that's fine. And so the first part of this problem on page 269, we really emphasize how this relationship is structured. We have Jill for minor whiplash injury, not minor, but less serious than Rima, who has very serious injuries. We have a contingency agreement, one of the rare instances where an attorney can have a stake in the outcome of litigation because we want to provide equal access to legal services to those who cannot afford it. And we have us suing this insurance company. And we determined that, yes, we can represent Jill and Rima, that at this point, we don't think that this is a non-consentable conflict. And then we went through the type of discussion that we would have to have in order to obtain informed consent. And the driving force of this problem is to make sure that if you have a joint representation scenario, on some level you have this discussion with both clients in this transaction. Because even though they are united in a common interest, now things change, particularly when money is involved, and particularly when one client can receive a much larger recovery than the other. But we talked about loyalty and confidentiality and the attorney-client privilege, and more importantly, how this information and confidences will be shared. And there is a built-in material limitation within this representation, starting out from the beginning, that would have to be communicated to the clients. And that is, Jill might not be able to be, in our advocacy for Jill, we may not be able to be as aggressive in pursuing her claim because of Rima's larger claim. So if they're both united, we might do some things that impacts how we represent Jill, but just because we know that this other client has a higher recovery potential. So that's what we did first. We talked about joint representation. We should note that should interests diverge, we might be in a situation where the parties may need another attorney, or there could even be a possibility where we have to get out of both representations. But we'll see that later on in the second version of this problem. Then we talked about imputation of concurrent conflicts. That's on page 270. We just made the point that for conflicts purposes, a law firm is one lawyer. So if this was a law firm and one of us had a conflict, that would travel all throughout the law firm. Now there might be ways that we can still continue representation. We're going to talk about screening a little bit later. We could take the person who has the conflict, maybe the person moves from another firm over to our firm, and then that conflict arises because we're representing the current client that this other attorney who transferred was against. And of course that former client of our new attorney will be concerned about that, but we could say, well, we screen them off. That person has no interest in this case, no monetary interest, receives no fees. We have set up a virtual wall between that conflicted attorney and the rest of the firm. We don't talk to him about it, we don't share confidences, he's off of the email list, doesn't see anything about it. And so we say that to the former client, and that might be okay. But that is just to illustrate that this conflict can go through the entire firm because we consider the entire firm, no matter how many there are, as one law firm. That's on page 270. From there, we went to 272, the top of the page. That's an example of directly adverse. An example of what we have in comment 6, which emphasizes this point that undivided loyalty really means something. And just because the matters are unrelated, when you have a divorce case and a car accident, you're still against your own client, and that's still directly adverse. Then we did the same thing on page 273. I thought you were my lawyer. 273, 274. We ran through the analysis under 1.7. But is it a conflict or not? If it is a conflict, can we get informed consent? And we concluded that the firm should at least withdraw from representing Kevin in the divorce case to avoid the possible adverse use of confidential information against Dory, our client, and our client in the accident case. We later find out that we're also suing Dory in the divorce case. So we should get out of that one at least. And we concluded that there probably isn't that much information, confidential information, that would be relevant in a personal injury case. So we may even be able to continue representing Dory, I think, of course, if she consents to moving forward. And we said maybe she won't consent to moving forward because this is a divorce, but she could. And we'll see in this next problem that she did consent, and then we have a problem about who we're actually suing, who is the actual client. We'll see that in another version of this case. And then from there, we did on page 277 the second version of this injured passenger case. So there, everything's going along fine, and now the insurance company is pitting us against our own client, and I think that's where we left off. And I think the last thing we said is, what can we do in this case? So here's our situation. Rima will get a lower recovery unless she sues Jill. We represent them both. We're going to have to advise Rima that she might not be able to collect in full unless Jill is sued. And then we also have an obligation to warn Jill that Rima might sue her. And I guess what that might entail. So what are we doing in this case? We said it's okay if both of them just want to move on. Rima takes the 350 and Jill takes the lesser amount. We move on. That's fine. But if they want to get the max, then that is going to be difficult. So what happens in this case? Can we choose one client over the other and just continue representing, or do we have to get out of both? And one way to figure this out is to think about what you have to do with both clients at the same time. Go ahead. Yeah.
I think you have to get out of both if they're not willing to take a lower amount.
Yeah. So that's the first question we asked. We said, you want to make this go away? We've been at this a while. This is a pretty good sum of money. I need both of you to consent because this is communicating about the settlement offer, and we'll be fine. But if not, if we want more, then why are you saying we have to get out of both?
Because you're still going to have, if you pick, Rima,
yeah.
then you still have an ongoing duty to, if you drop Jill, you still have an ongoing duty to keep promises to Jill.
That's good. So notice this is the introduction. I know we haven't done it yet, but if we drop Jill, she becomes a former client. We don't just wipe our hands about that matter. We still have continuing obligations. Confidence is under 1.6. We can't harm or disadvantage our former clients. We're going to see that under Rule 1.9C when we talk about former clients. And so that would be picking one client over another, which really shows us really the essence of this conflict. And also, I said think about what you have to do at the same time. And this is what really tells us that both clients need counsel. As a lawyer, we would need to pursue full recovery. And pursuing full recovery, you see on page 278, means that we will have to sue Jill, particularly since this is a comparative analysis. We have to sue Jill. And at the same time, we represent Jill. So how can we sue her and then protect her at the same time? So we're advising Rima about all of these things, using confidences that may be detrimental to Jill in order to advance her claim if we stay in this. So no loyalty to Jill because we pick one over the other. And Jill, conversely, needs a lawyer to attack Rima's credibility. So there's really no way that we can say resolve this. Now, what if both parties consented and said, we don't want to start all over again, we recognize this, and do what you have to do and just move forward? Could that work? Can we get consent based upon everything I explained about this conflict to move forward? Can we paper over this conflict and just move forward? Can we say, well, Jill consented to this. She knows that we have to sue her and maybe even damage her credibility, but maybe we'll get something out of it still. And that's the risk we have to take. Can we do that, Mr. Mann?
Yeah, we go against B3, the same action transaction.
Mm-hmm.
The same both sides of the B3 switch.
Yeah, you cross-examining your own. So that's an example of something that is non-consentable. So you have to be careful of that. In practice, you can have informed consent, but that informed consent has to be meaningful. So then you have a client sort of consenting to you being allowed to hurt her. And almost switching sides. Because you'll be saying, in order to win, we have to turn against you and you may get something, but that is secondary to what I'm trying to do for Rima. So you see how that's unworkable. But that doesn't necessarily mean, and this leads into my next thing, positional conflicts. We're going to page 278. This is interesting. So, what do you think a positional conflict is before I have a hypo? What do you think a positional conflict is? Yeah, what do you think a positional conflict is? Let me sort of take one, and then I'm going to show you one with sort of a advocacy argument that you make in terms of the law, and then my hypo is going to be based upon two clients that a law firm has an actual case. So let's say we are we're at Stuyvesant Harvest, just to take an example. We're litigating two things, and we're litigating something here in the Western District in Kentucky, but we're also part of a sort of a larger litigation that's happening out in California, Ninth Circuit. Ninth Circuit law is completely different than what we have here in the Sixth Circuit, but the firm is on both cases, taking different legal positions in the Sixth Circuit than we would in the Ninth Circuit. The circuits are in conflict, and one day the Supreme Court may take up the issue, but we're arguing one thing in the Sixth Circuit that is diametrically opposed to what we're arguing in the Ninth Circuit, and we are the same law firm. Can we do that? Can we do that? And if we did that, what would we have to talk to our clients about? So we're doing what lawyers always do. We are distinguishing, finding nuance, making analogies. But we're doing two things that directly contradict each other in terms of our advocacy. In the Sixth Circuit, we're arguing one thing, and in the Ninth Circuit, we're arguing another. So in the Sixth Circuit, let's say we're arguing for the Commonwealth of Kentucky's eminent power to take land for public purposes. And we're just saying that public is unlimited, and the public trust means something, and the Commonwealth must be able to advance its interests. Notwithstanding the impact to citizens, that's what we have the Fifth Amendment for, and they'll get compensated, whatever. But we make the argument in the Sixth Circuit for broad governmental power. Ninth Circuit, we are working for a grassroots group of tenants across the state of California, and they make the different argument. Access means something. State power cannot be expanded so much that it tramples property owners' rights. There should be a way to integrate people within the property scheme without using the Fifth Amendment in a way that unconstitutionally usurps the bundle of property rights that all citizens have. So two fundamentally opposed viewpoints. Can we do that? Yes. Yeah. So how would you go about getting consent? So you can do it, but you have to be careful because of what you pointed out in terms about precedent. So what would you have to tell your Kentucky client and your California client? Look it up. Right. So that's not likely, right? Right. You can't tell me why, but that's good. So that's how the conversation would start out. I tell the Ninth Circuit client that we are working on the Sixth Circuit matter, taking a different viewpoint. Tell the Sixth Circuit client the same thing. There's a conflict in the circuits. These arguments that we're making on behalf of you are fine. There may come a time where this could be something that the Supreme Court may take up, and at that time we will have to drop out from representing both of you because we can't be on both sides of the V. But we can make this argument that is different in these circuits. We are arguing the law in the Sixth Circuit. We are arguing the law in the Ninth Circuit based upon, and we're making a good faith effort to move forward. And so that's fine. Those are a positional conflict. We have to always be aware that at some point we can establish precedent, but that precedent has not been established yet, and it won't be until it reaches the Supreme Court. Now, of course, we can't be on both sides of the V in the Supreme Court, and so we probably have to drop out. But if you look at comment 24, it talks about the things that the mere fact that advocating a legal position on behalf of one client might create precedent versus the interest of a client represented by a lawyer in an unrelated matter does not create a conflict of interest. But we are concerned when it is sort of this related matter, like in my hypothetical. Ordinarily, a lawyer may not take inconsistent legal positions in different tribunals at different times on behalf of different clients. If there's a significant risk that a lawyer's action on behalf of another client will be materially limited, then the lawyer has to make sure that both clients know about this. But they talk about different factors. The clients need to be advised of these risks. Where the cases are pending, I told them about that. Whether the issue is substantive or procedural, temporal relationship between the matters, and the long-term interest of the clients involved. So I don't think there's a risk of material limitation. I'm making my argument based upon Sixth Amendment law, and I'm making an argument based upon Ninth Circuit law. So that's fine. But there will come a time where we will probably have to drop out if this goes all the way up to the Supreme Court. So that's an example of a positional conflict when you're taking opposing viewpoints. But what happens when you have two clients? So this actually happens. So a large New York law firm that was representing the city of New York in a gun manufacturing case. So the mayor of New York has always spoken about the dangers of gun violence. And the mayor comes to us and asks us, will we help represent the city's legal department? The city doesn't have ample resources to advance what will be a long and costly litigation against a gun manufacturer. And so they need a firm like ours to sign on to the work that the city's legal department is trying to do. They need a large law firm to lead this case because we want to go up against a gun manufacturing company, and they're going to have a large group of lawyers. The legal department seeks our help because they know that our firm does not represent any gun manufacturer. So at least initially, we don't have any conflicts because of the clients that we have. So we do extensive research, discussion among the partners, and we finally agree to represent the city in this matter. And we do so pro bono, not charging anything. We believe in the public interest. The lawsuit is going to name 4 major gun manufacturers as defendants, and it alleges that the gun manufacturers support an illegal market in guns that criminals use to commit their crimes throughout the city. The legal argument is that the gun manufacturers are creating a public nuisance in violation of common law. So we're seeking an injunction to prohibit the gun manufacturers from selling guns to gun dealers who are known to supply guns to criminals. So we want to target a particular segment of the retail market and hopefully destroy that as a way for criminals to obtain guns. So we decided to do this. We're moving on, and we're 2 years into this litigation, and we've been doing fairly well. Then one day the phone rings, and one of our partners receives a call from the General Counsel of Global Pharmaceuticals. Global Pharmaceuticals happens to be one of our largest clients. Global Pharmaceuticals has found out that we are representing the gun company. Suing the gun company. And even though guns and pharmaceutical products are different, Global Pharmaceutical is really concerned about this argument that we're making about public nuisance. That public nuisance argument can be expanded broadly, and maybe it applies to Global Pharmaceuticals. Global Pharmaceuticals has some liability, and there's an allegation that Global Pharmaceuticals is flooding the market with a drug And the plaintiffs are asserting that Global continues to sell this drug to discount drug stores, even after company officials hear about rumors that this drug is highly addictive, has devastating consequences. There were rumors that it's easy to fill prescriptions on this drug, that forged prescriptions are flooding the market. And one freelance journalist quoted an anonymous source who said that she obtained the drug at a drugstore using a forged prescription. And Global Pharmaceutical allegedly knows about this illicit market, but has encouraged it to expand because they're making billions of dollars. Our firm is not representing Global Pharmaceuticals in a series of wrongful death actions, but Global has some liability. So we have a choice to make after this phone call, because the General Counsel of Pharmaceuticals says this: you have a conflict of interest, and you should withdraw from representing the city in a lawsuit against the gun manufacturers. This public nuisance argument can expand and undermine the interests of one of your most lucrative and long-term clients. If the firm does not withdraw from representing the city, the management of Global Pharmaceuticals might decide to terminate our long-term relationship with your firm and obtain legal services from another firm. So we have a meeting of the Partnership Management Committee in 1 hour, and we have to figure out whether or not we're going to continue representing New York or drop out in terms of our client's wishes. So our client has argued to us, we recognize this conflict of interest, you need to get out. Public nuisance can be applied to our drug manufacturing, we could be subject to liability. And one way you can help us is to get out of this litigation. We're asking you as your long-term client. Must we withdraw from representing the city against the gun manufacturers? What do you think? It's hard for you to say no, but I think that's a noble answer, and tell me why. That's good. You say no.
I say no because one, your long client is taking speculation about something. They don't necessarily have any like precedent to act upon.
Yeah, that's true.
And so it shouldn't be their call to make legal arguments about why you should stop representing their client.
Okay. Oh, that's true. But money is involved. A lot of money. We're gonna lose a lot. We're gonna lose a lot of money if we stay in this. They will probably go somewhere else. So how would you express what you just said to me in a way that doesn't turn off the client, and maybe we'll still be able to keep the client? Everything you said is true. Particularly the part like you can't dictate to us who our clients are based upon speculative legal arguments that haven't even occurred yet. This is our litigation. This is what we're doing. But I don't want to say it that forcefully because I don't want to lose this business. Is there any way to talk to this Global Pharmaceutical client and maintain a business relationship?
I would say something that we need to do it because I don't know what anybody to soften the blow. But I guess one way you can say it is there's no precedent that we come across that would like definitively like confirm your views of what could happen if we continue this representation of the city. And
And he's going to say, yeah, I get all that, but that's that legal stuff. I'm talking about practical reality. Even if this doesn't go anywhere, the publicity is going to be so bad when you take over this public nuisance case. It's going to impact our reputation. That's going to impact our credit rating. That's going to impact our bottom line. And I really, really think you should get out of this.
this is still much more interesting. That's still a lot of speculation. That's not grounded in like hard facts because you're carrying. Well, I can certainly see there are some similarities between the two situations. It doesn't seem so confident to create at that point in time a viable firm of release.
So, but then, okay, everything that you said is true. So we're in the classroom. I'm just trying to sort of make it real. So the General Counsel of Global Pharmaceuticals is going to buy that. We make all the reasoned arguments. We know all the rules that we learned in the classroom. We say it really nice, explain it, and then it comes down to this. Look, we've been with you for years. You're making a lot of money. You have a choice to make. You can continue doing your pro bono work that isn't paying you anything and taking a lot of time. Or you can drop that client, make us happy, and we can move on. Everything's fine. What can I say about that?
I see like their vision only was kind of ethical and oral too.
Yeah, ethics lawyer. Lawyer statesman versus modern practice and money. What do you think happened? And this is a major firm. It's Wild Gotcha. Can they stay in it?
Yeah.
What do you say?
Probably not just because I'm cynical when it comes to certain types of major law firms.
Yeah, yeah. What's it
I think they did because if they didn't, I don't think we would talk about it.
You think they did?
I think they did stay in it because if they didn't, maybe we wouldn't talk about it.
Oh, no, they didn't stay in it.
Oh, man.
No. But they didn't stay in it, but they tried to make it nice, like what we were just talking about. They tried to use the rules of professional responsibility in such a way that they made a noble decision. So they got really criticized for it. The law firm is Wild. And they made a decision to withdraw, but they said they didn't like it was a positional conflict that would impact the way that they could represent these clients. And the quote was, certain potential positional conflicts involving the position of long-term existing clients and those being advanced in the gun case necessitated our withdrawal from this action. So, nice wording, but it really came down to dollars. And they were roundly criticizing all the bar terms of choosing money over principle, so that's what happened. Good. One thing we have to look at before we finish this chapter is conflicts involving prospective clients. Now, one thing, one reason that we sort of emphasized for 1.6 was there is this, one of our touchstone duties is to preserve our clients' confidence. And this carries on. We'll see it when we talk about former clients. You have to preserve that, current clients, of course, and now even prospective clients. This is duties to prospective clients. Now notice this is a nice review of what happened at Talkstad. Remember, so Talkstad went from being a prospective client to being an actual client. So what do you think distinguishes the Talkstad scenario from what we're talking about here? Why do we find an actual client in Talkstad? Remember that's the case where the wife comes in, her husband, was the victim of medical malpractice. She comes in with this co-worker. They talk to the lawyer. The lawyer thinks it's just preliminary, but the court ultimately concludes that under either theory, contract or tort, that there was an attorney-client relationship, and even proves the case within the case. But for the lawyer's negligence, the client would have been successful, more than $650,000. So that was a case where, in an initial interview, the prospective client becomes an actual client. What made the client sort of transform from just being prospective to being actual in Talksted? Yeah.
Kind of left the conversation hanging and said, I'll get back to you, and so she was not expecting that there was any action.
That's right, reliance. And that reliance caused the statute of limitations to pass, and that reliance went back directly to the attorney's competence, did not exercise the ordinary standard of care by doing the research, and all of that added up to medical malpractice. Here you could have some of the same dangers, and when we do the problem, you'll see, now we're looking at the internet, and it might have a website, and we could be your attorney, check out these questions, answer and fill out a little bit of personal information. Now, does that move you from just being a prospective client to an actual client? And that's what we're talking about when we talk about the secret affair. But what about Rule 1.18? How does this work? So you see the first part of Rule 1.18a. It tells us a consultation. So a person who consults with a lawyer about the possibility of forming a client-lawyer relationship is a prospective client. Now notice this is the confidentiality component. So even if nothing comes out of this discussion, we don't become the attorney. Even when no client lawyer relationship ensues. So now you see why, like the beginning part of this course, we were just putting together the attorney-client relationship. So this helps you analyze are all these things in place that will tell us that an attorney-client relationship has been formed. So even when no client-lawyer relationship ensues, I'll just put a lawyer shall not reveal. This is mandatory. Shall not reveal that information. And there's a reference to 1.9 which talks about former clients. So even if no relationship ensues, a lawyer who's learned information from the prospective client, confidences, other things, shall not use that information, except as 1.9 will commit with respect to information of a former client. So that's what I'm saying. Just as you can't harm a former client by using information that you gained during the previous representation, so too you can't harm the prospective client from information that you gained, even though no attorney-client relationship has been formed. See? So a lawyer who is subject to be, in other words, a lawyer who has to keep these confidences gained through this preliminary discussion. So notice this, we're comparing a current client with this prospective client. Shall not represent a client with interests materially adverse to those of a prospective client. The same, substantially related matter. So, and that's information that you would have received from the prospective client that could be significantly harmful to the prospective client in that matter. That's just letter C on this paraphrase. You see this chart, top of page 281. You cannot continue representing a current client if you received information from this prospective client that is significantly harmful to the prospective client. If you reveal that to your current client. So you reveal it to your current client and say, oh, that's good, let's use that. We can't use that because that would hurt the prospective client. So this just shows that you have to even protect a client when no formal attorney-client relationship has been formed. That's the top of page 281. So, and then it says you can avoid that type of situation by having an agreement with the prospective client that information disclosed will not preclude the lawyer from accepting other representation. So notice, there is a sense about imputation like we talked about earlier. If a lawyer is disqualified from representation under this paragraph, no lawyer in the firm can knowingly undertake or continue that representation. So notice that. So you're talking to a prospective client, you find out this information, it conflicts with one of your current clients, that conflict runs through the firm and is imputed because we are one lawyer. If you look at the comments, it says that prospective clients receive some but not all of the protection that actual current clients receive. We cannot reveal this information. So, and this duty exists regardless of how brief the initial conference may be. The comment 3 tells us that. But the rule also says the lawyer should go on a full-scale fishing expedition to get all of this information because that opens you up to more exposure to conflict. You don't get the information necessary to make that preliminary assessment about is the representation within your expertise, do any current conflicts exist, and then you can move on from there. If you look at comment 3 and 4, it talks about that. That is on page 281 as well. So again, even if you have this type of conflict, when a lawyer has received disqualifying information, as defined in paragraph C, that's that information that you receive from a prospective client that could significantly harm that prospective client if you reveal it to one of your current clients. Even if that representation is permissible, if you get informed consent from the affected client and a prospective client. confirmed in writing. So, notice you have two approaches. You can get informed consent from affected client and prospective client, or screen. So it gives you two ways. One way is you could just say to your affected current client and the prospective client, this is what's happening, this is the impact, this is the conflict, get informed consent in writing, and that's fine. Or screening. So the lawyer, this is what I meant, just getting enough information to make a determination about the conflict or not. The lawyer who received the information took reasonable measures to avoid exposure to more disqualifying information than was reasonably necessary to determine whether to represent the prospective client. The disqualified lawyer is timely screened from any participation, and written notice is given to the prospective client. So screening is talked about in D2. So this recognizes balance. Don't get so far into corporate representation that you have all of this disqualifying information. Only enough to make you determine whether or not representation is feasible, whether or not conflicts exist, and if the lawyer has taken reasonable precautions not to avoid receiving more disqualifying information, and this is about on page 281 to 282, and the disqualified lawyer is timely screened. So that means no email access, no discussions at meetings, no shared documents, nothing. Virtually screened off from this. No fees from this webinar either, so you don't get paid for it because you're not working on it. And give written notice to the prospective client. That's to allow the prospective client to protest. Now, the prospective client might file a motion to disqualify or something, but you have to provide notice. So either way, you're having a discussion with the affected current client and the prospective client, and then give you informed consent in writing. That's fine, then we'll move on. If not, if you choose to just do screening, you still have to talk about the disqualifying lawyer being effectively screened, and that will be in the notice that you send to the prospective client. We detected this conflict, this is what we did. We screened all lawyers who received disqualifying information. These are the systems that are set up to ensure that the lawyer does not participate in this matter. The lawyer is not sharing any fees in this matter. And if you have any further questions or comments or concerns, forward them to the firm. So this little hypo, last case in chapter 6, gives us some practice with prospective clients. The secret affair, page 283. So this is real. So notice this is a good extension of what we did with our TalkStat. In TalkStat, we had people coming in and there was this conversation, and as we pointed out, that conversation progressed so much to the point where we had the client in quotation marks relying upon the attorney's advice. So much so that this has the limitations back. Here, sort of a converse situation, we are trying to establish the attorney-client relationship. So we know we're going to have to protect this information. We know that we cannot represent a current client whose interests are materially adverse to those of a prospective client. What does materially adverse mean? Is that the same as directly adverse, or what's the difference between those two? This seems like a conscious choice of language. It's directly adverse, you have that current client. Prospective clients were just starting out and don't really have a formal relationship. What do you think materially adverse means? What do you think? Materially adverse. And the comments really don't tell us, but I guess we sort of get some information. What do you think it means? Materially adverse. I mean, I guess sometimes it has to be something worse than just bad. Yeah, go ahead.
Wouldn't you do something like definitely affect the client in any way?
Yeah, yeah. But what do you mean definitely?
Like there's no way it wouldn't be negative that could use the admission kind of.
That's good. That's good. So no real definition, but we want something that really harms this prospective client. So notice, and no real definition, but if you look at comment 6, it says under paragraph C, the lawyer is not prohibited from representing the client with interests adverse to those of the prospective client in the same or substantially related matter, unless the lawyer has received from the prospective client information that can be significantly harmful if used in the matter. And that's what you're getting at, definitely. Some type of harm will result from it. So this, you can see that this is going to be a fact-specific determination. So we want something significantly harmful. Goes against the prospective client's interest. And that's a little bit different than directly adverse, because there you have a current client and interests are pretty much crystallized and you know what those interests are. Here, we don't have a full relationship, so we're looking at something that will really hurt. I know that's not a good definition, but that's probably all we have under the rule. So on page 283, this last problem in chapter 6, secret affair. So we have this is our firm, and we have a way of making sure we get clients. And we do that by our website. What are our rights? We may be able to help you. Visitor comes on and clicks on the electronic form, and the first line in the form asks the visitor to the website, wondering about a legal issue or problem that you have. The firm asks for basic information, and this disclaimer is what is going to drive this our discussion. I notice that I will not be charged for the response that I receive from the firm. So no money's changing hands. We had that in talks, remember, no money changed hands, but we still found an attorney-client relationship. I agree, I am not forming an attorney-client relationship by submitting this question. That's a powerful disclaimer. I also understand that I am not forming a confidential relationship. So one of those is good, I think, that I'm not forming an attorney-client relationship, I understand that. But confidentiality, that might be a little murky. We might have to come back to that. So one of the things that the disclaimer does is it says, no attorney-client relationship, no confidential relationship. Then on the top of page 284, I further agree I may retain the firm only by entering into a written fee agreement. So that's another way of saying this is not a formal relationship. This is pretty much intake, and we are not establishing anything, only getting information. By submitting the form, I signify the agreement to the foregoing terms, or you can cancel, and then the person submits, and we're reading along, and we have what we have on page 284. Maria DeCourcy, she writes that she wants to have a divorce action against her husband who's living with another woman. They've been separated for 3 months, looking for a lawyer to handle the divorce as well as child custody issues, and then admits this confidential information. I had an extramarital affair several years ago. The husband does not know about it. Nicholas does not know about it. I wouldn't want him to find out because that's going to become an issue in the custody hearing. Then the person says, I like your website and would like you to represent me. I have enough money to pay you for my savings. We as attorneys type back a quick email. Sounds like you have a genuine need for legal representation. So that's a little bit different than talk said. I'll get back to you. I don't think you have a case, but I'll get back to you. We're not saying anything. We said, it sounds like you might need us. Let's talk further. If you like, you can call me at my office tomorrow. We can talk about whether we should represent you. Then we start thinking and said, oh boy, maybe we should do a conflicts check. We do so, and we know now that we already represent Nicholas. Do a quick check for conflicts of interest and discover a few weeks ago one of our partners agreed to represent Nicholas, who wants to divorce Maria. So a couple questions. Is Maria a prospective client? May the firm continue to represent Nicholas in the divorce case? So this is the situation. How do we get out? We have a firm already represents Nicholas. Current client. And then that would be against Maria. Is Maria a prospective client? Which is a shorthand for asking, do these waivers actually work? Is there a express or implied contract to represent Maria based upon what we have on this website? One other way to look at it is this disclaimer effective? What do you think? Yeah.
I don't think they're necessarily that effective because when you look at subsection A of 1.18, it says a person consulting a lawyer about the possibility of forming a relationship. So even though she's agreeing that they're not right now forming a relationship, they're still discussing the possibility of that.
Okay. So what does that tell you? What is
So
that?
that would make her a prospective client then there, and she said, I think.
As soon as it, well.
If not then definitely when he emails her and says, like, he actually responds to it.
Yeah, I think it's murky. I think a couple things. One, I think that the law firm's website, I think, prevents the formation of an express or implied contract to represent Maria. But I think what you're getting at, and I think this is the problem, is when they talk about confidential relationship, that is unclear. And so those disclaimers about confidence are unclear, and that would sort of lead Maria to reasonably believe that her revelation would be confidential, and that would lead to at least the understanding that Maria is relying upon this attorney, whatever the relationship is, to preserve his confidence. So I think, I came at it another way, but I think what you're saying is right. There is this sort of budding relationship between the attorney and the client. I think they're right in saying no attorney-client relationship is formed, but this confidential information is murky. She may be reasonably believing that this revelation will be confidential, but this is really damaging information. You also have to look at the content of the information as well. So, if that's true, can the firm tell Nicholas about this, the extramarital affair? Can we help our client Nicholas? We got this good information. Can we tell Nicholas about this?
Are we saying she is a prospective client right now?
She's blurry. She isn't. We don't have that formal relationship, but because she's shared this confidence, I would say she is.
Well, then, even though, based on B, even when no client-lawyer relationship ensues, a lawyer who has learned information from... So, I don't know. I just think it'd be risky to try and, well, I guess ethics-wise.
Yeah, but would you tell Nicholas this information?
Based on the rules, if I'm following the rules, no.
No, yeah.
I guess.
You can do it, yeah.
Yeah.
Even if there were no rules, I wouldn't tell them. But yeah, so notice what you're saying is this. We have a client whose interests are materially adverse to those of a prospective client, and it would be the same matter, and we'd be using this information that would significantly harm that prospective client. I mean, this is devastating information, and if we did, then Nicholas would certainly be triumphant in this custody hearing, maybe even the divorce itself. The firm had a duty not to reveal Maria's secret to Nicholas. And so this was an actual ethics opinion, and it said this. It said a couple things. It said, this disclaimer, I agree I'm not forming an attorney-client relationship by submitting this question. It says that the law firm's website disclaimer did prevent the formation of an express or implied contract to represent Maria. That's fine. But the confidentiality section, I also understand that I'm not forming a confidential relationship. The committee said that's really ambiguous. The disclaimer as to confidences was not so clear as to prevent Maria from reasonably believing that her revelation would be confidential. And you can tell by the type of information that she discloses, that she expects that information to be protected. We shall not reveal that information, and we shall not represent a client of interest materially adverse to those of a prospective client. And certainly Nicholas would be materially adverse. Now, while the committee didn't express a final opinion about Nicholas, it did say that Nicholas the firm may be disqualified from representing Nicholas. I mean, I think that's clear. Think about it. You don't even drop. She's a prospective client. Okay, we're not going to do that. We're going to keep this information confidential. We continue representing Nicholas, but we cannot use that information because we have to protect the information of the prospective client, Maria. So we're going to be limited in what we can do for Nicholas. We can't even go down the road of using this information in any way. Think about undivided loyalty too. Think if Nicholas finds out that we, by some way that we interviewed this prospective client, we have this information and don't use it. I mean, that's competency issues, that's diligence issues, communication issues, and so it just becomes even more complex. So while the committee didn't fully rule on it, I think you can't represent Nicholas either because you can't use that information. This is key information that would help advance his plan. Now, Chapter 7 sets up, we're still doing 1.7 and that type of thing, but now we're doing in a particular context. Yeah, go ahead.
Before we move ahead, I just had a problem with what websites can now provide for prospective clients. So I see it as a law firm or even a first party can use this as a trick to get the attorney to drop that client.
That's good.
What if she knows that her husband's being represented by she's represented by another attorney?
Yeah.
Another attorney wants to work her.
Right.
Wants.
And she goes all around town just talking to people. I noticed that. We have this. It's not in the rule, but it's one little sentence in comment 2. So comment 2 talks about what consultation means, and the last sentence of comment 2 is this: a person who communicates with a lawyer for the purpose of disqualifying the lawyer is not a prospective client. So if you're doing that to sort of get in with the lawyer, like if she knew that we already represented Nicholas and she's trying to get us to be conflicted out, we're not going to view her as a prospective client. So I don't know if that means we could use the information. Maybe, yeah, she's not a prospective client. But you're talking more about a structural issue. How do you structure the language in the website so that that doesn't occur? Yeah. Well, I don't know. I think it's going to be fact specific. I think in our hypo, it was pretty good, the part about forming an attorney-client relationship, but they should have also said something about confidences. Not that, well, I understand I'm not forming a confidential relationship, but maybe something from the rule itself that confidences of the prospective client are protected. And you have to be really explicit in that. Here, it was just, I'm not establishing a confidential relationship, and that wasn't really true. So that was so ambiguous that the committee said, well, that doesn't give the prospective client enough notice about the attorney's responsibility. First and foremost, we have to protect that confidential information. So one approach, I think, is, I mean, you don't have to put the whole rule on the website, but you could, as we've been illustrating throughout class, you can take a component of that and put it in there. So instead of just saying, I understand I'm not establishing a confidential relationship, maybe in terms of the formal attorney-client relationship, but you need another sentence that says, confidence of the prospective client will be protected. And so that's why the court says, the committee says that this information cannot be revealed to Nicholas, and perhaps the firm would also be disqualified for representing Nicholas. I think it would be, yeah. Current client conference, particular practice setting. So we're still doing the same thing. And so you look on page 286, and it's just a review of what we've been doing. Is something directly adverse? No. Is it materially limited? Maybe. If it's one of those two, we have a conflict, and then we say, can a lawyer provide competent and diligent representation? Does the lawyer reasonably believe that he can do so? If so, can we get informed consent? And if we do, then we can move forward. What about this little hypo on the bottom of page 287? Can someone explain to me why this attorney was suspended for 6 months? So this is one of those dangerous scenarios where you have joint representation. This attorney, Baltimore, he represents a mother and son, Ruth and Jan, and they own a nursing home. They're going to sell it. It's on the top of page 288. They, of course, money's involved. They had agreed that the proceeds from the sale would be distributed a certain way. The mother then refuses to give her son his share. She does not pay the attorney's bill for legal services, and the attorney, Baltimore, then terminates the relationship. So this is an attorney you see from these facts who terminates the relationship and doesn't fully understand the continuing obligations, even if the attorney-client relationship formally ends. So then, of course, the son sues the mother, Jan sues Ruth, and the former attorney, Ruth, gives Jan's lawyer information without Ruth's consent. Describes her business affairs, characterized her conduct as tax avoidance, and sent the son's lawyers copies of Ruth's tax return. He also informed the IRS that she took action contrary to his advice, failed to state her income correctly. Now there's some rules listed there, and it says the attorney was suspended for 6 months. How would you analyze this violation of the rules? This is good practice for your writing time. So you have all the rules there. What did he do that was wrong? I know somebody's gonna say everything, but what did he do that was wrong? So do you think this attorney just thought, well, the relationship ended so I can do what I want to do? Or that's what it seems like. What do you think about this? So, and we haven't done former client yet, but think of this. After Ruth does not pay the attorney's bill and he terminates services, the representation, he still has continuing obligations. So the court found that he violated Rule 1.7, 1.6, and 1.9c. But what about those rules? What are the violations there? So why is it a current conflict violation under 1.7? Probably because you continue to represent Jan. He gives Jan's lawyer this information without his former client's consent. So then you're going against your former client, you're disadvantaging your former client, undermining that interest. That's the 1.9c. And then you're violating the rule of continuing to preserve confidences. So that got 6 months suspension. So that tells us this, that a lawyer usually cannot represent one client against a former client. That's what that would be. You continue on in this joint representation, you give Jan's lawyer all of this in a separate litigation, and it's still really bad. That's why I got 6 months. Look on page 291. We're going to set up the problem that we'll do when we come back. So now we're taking this conflict rule and taking it to a specialized context. And one place where conflicts can arise is when the attorney represents the organization. So the organization, of course, is an inanimate object, but it acts through duly authorized constituents. And we want to make sure that those constituents know who we represent. The attorney represents the organization. And so, we have Rule 1.13, organization is client. You have the chart on 291, but so first thing we see is a lawyer represents the organization. I'm just paraphrasing. The lawyer represents. And the organization is acting through duly authorized constituents. So the lawyer is always concerned with the best interest of the organization. So it goes through a sort of a long scenario, but if we know that someone in the organization, a decision maker, officer, employee, other person, is engaged in action and intends to act or refuses to act in a matter related to the organization that is a violation of a legal obligation or some violation of law that could be imputed to the organization, we have a responsibility. If it could result in a substantial injury, to the organization, this is called reporting up. Then the lawyer shall, there's a lot of reasonably here, proceed as is reasonably necessary in the best interest of the organization. So here, you are trying to get the organization's attention. No one's doing anything. There might be some conduct that's a violation or something that's illegal. You think that there could be a substantial injury to the organization. Then you shall proceed as reasonably necessary in the best interest of the organization. So, but there's a lot of reasonables in here. So for example, unless the lawyer reasonably believes that it's not necessary in the best interest of the organization to do so. So, long way to saying you have to be deferential. You might not be. You may totally disagree with the decision making, but if it's not going to lead to substantial injury to the organization, you have to defer. The lawyer shall refer the matter to the highest authority in the organization. So that's when you've worked your way up the chain and everybody's saying no. This is called reporting up. So that means when you're working your way up to the board of trustees, maybe the vice president, he doesn't want to do it. Then you go to the chairman or the president or chief operating officer, he doesn't want to do it. Then you go to the board of trustees, but it's going to depend upon the corporate structure that you're in, and that is why the rule says to the highest authority that can act on behalf of the organization as determined by applicable law. So this is reporting up. And then letter C talks about reporting out. So notice you work your way with any corporation, things still aren't working, and you can report out. This says except as provided in paragraph D. Paragraph D talks about a situation where you're investigating, so you're not going to report anything. Now that's not a situation where they report you to investigate so that you can cover something up. That's not the case. You are doing an honest, good faith investigation, trying to find things out, and this is like a client coming to you with a problem, you're just investigating. So no revelation there. But letter C talks about reporting out. So despite everything that you do, moving up the chain, talk to this level, nothing. This level, nothing. So you go all the way up to the highest authority in the organization that can act on behalf of the organization, and you're still striking out, then you may be able to report out. So the highest authority refuses to act, and then you have a decision to make, am I reporting out? Now look at all these reasonableness, and I'll read with this. If you look at 1.13 C2. C1 says all of your internal efforts have been unsuccessful. And then the lawyer reasonably believes, that's one, that the violation is reasonably certain, that's two, to result in substantial injury to the organization. Then the lawyer may, that's permissive, reveal such information relating to the representation, whether or not 1.6 permits such disclosure. So another exception to 1.6, if you reasonably believe that it's reasonably certain that there's going to be a substantial injury to this organization, you're not precluded by 1.6 about revealing it. But notice there's another disclaimer, but only if and to the extent the lawyer reasonably believes necessary to prevent substantial injury to the organization. So you have a lot of reasonably believes before you report out. So there are a number of layers before you actually report out. And then finally, letter E talks about taking the steps to inform the board of directors if the lawyer is fired or forced to withdraw for doing the right thing, following through. You have to explain that the organization is a client. That's 1.13F. If someone has the misinterpretation that you represent them simply because they work for the organization. And then finally, letter G, there may be a situation where a lawyer can represent the organization and employees of the organization subject to rules 1.7. In other words, there might be a discussion that would involve informed consent if you're representing a constituent of the organization as well as the organization itself. That consent must be given, though, by someone other than the individual who is being represented. That's 1.13G. So you'll see in the comments that, and that's why there's probably so many reasonably believes in 1.13 before you report out. There is a level of deference that the attorney has to exercise when he's working for the organization. So what we're going to do when we come back is we're going to start on page 299, my client's subsidiary. So this is Dory Hathaway again, but a new wrinkle. We're now suing a corporation, and we have to figure out who is the client before we analyze the conflict. Have a good weekend.